and welcome back to the studio where there's been a lot of discussion, a lot of activity. We've been critiquing essentially the prosecution's closing argument, and I'm joined by Ken Belkin here, criminal defense attorney.
Thanks
and we also have a Skype guest that we're going to get to in a moment. But Ken, first of all, to talk about the prosecution, the first prosecutor, we loved her. We thought she was very, very effective. Why did you like her?
Oh, so passionate. Conscious choices, deliberate decisions. I mean, she was magnificent. She came out of the gate swinging. She wants justice for the Faulkners. I mean, I'm very shocked that the judge is allowing them the leeway to allow two closing arguments from each side. Judges usually are loath to do that.
Yeah, well, we saw it happen with the defense. But what we really loved about the female prosecutor in the beginning is that she was, like you said, emotional, but she was also using a lot of techniques that were very, very effective.
Strong.
So one is that catchphrase, conscious choices. Oh my gosh, I just
deliberate decisions.
Yeah, I just had a moment of a blank. Deliberate decisions, conscious choices. Why is it so effective to hammer that home?
I mean, that is a great tagline. That she should go into advertising. She could have a great career after this. But, you know, look, she was magnificent in her use of the visual props.
Right.
She really engaged the jury. She was fluid. She moved around, passionate. You could tell. You could see the yearning for justice in her eyes. God, I mean, if this kid, Eric Campbell, if he could have had defense attorneys that were half as passionate and maybe had Southern accents,
right,
I think that would go a great deal with
So
this
you
jury.
think that the Southern accent was effective because why? People can relate to it on the jury, or why does it matter?
Yeah, I mean, it sounds like his defense attorneys came straight from, you know, out of a northeastern law school, and the only job they could get was as public defenders in North Carolina.
So it matters where you are trying the case.
Yeah, you got to relate.
And whether they feel like you're one of them, basically.
Yeah.
And there's a certain charm, especially for us, people with that
Oh,
Southern
I think
accent.
I'm in love with that prosecutor.
Yeah.
That accent is magnificent.
Right, and then like you said, the visual props, but also, so the repetition, and then she goes through the list of the weapons to just really hone in on the horror of it all. The crossbow, you know, the sword. It's simple, but it's effective to just list those weapons.
I mean, she dismantled the defense's arguments. The defense should have raised the fact that, yes, there were weapons, but Eric Campbell did not use them. She went through the weapons, the injuries, the fact that the injuries were so extensive that they could not have possibly been caused by one assailant. I mean, the people had defensive wounds. This was two people that are murdered. If they have defensive wounds, are they really being overpowered by one individual?
Right, that was the main
Begs the
point.
question.
It seems like they were relitigating that issue in their closing because that was their main point, was proving the fact of why it couldn't have been done by one person.
Yeah.
By showing you the evidence, by talking specifically about what the medical examiner found in terms of those defensive wounds. I just want to bring in Brendan Ahern. He is a former prosecutor turned criminal defense attorney, and he's joining us via Skype, and he's been watching along with us. Hi, Brendan.
Good afternoon, Amy. Thank you, and good to be with both of you.
So what was your take on the prosecution's closing?
Listen, I tend to agree with the both of you. I understand why the defense has two people up there making two different arguments or nuanced arguments because they can present a scattershot defense because they are looking for a theory that the jurors will accept. Having the two prosecutors, I think it adds a mixed message. There's some conflict of message, and I think I agree with the both of you that first prosecutor hit it out of the park.
Yeah, it's almost a circumstance of less is more here, and to bring that second prosecutor in, it seemed like for me it made the closing less effective. Some people may have liked that approach, but like you said, it may have been stronger if the second prosecutor at least had been a little bit more focused. It seemed like he was just talking and talking, but there was no real order or structure to what he was saying.
It's one of the dangers when there is so much evidence here. You have the autopsies, you have the medical examiner's testimony, you have the weapons, and you have this event that really took place over a tremendous period of time. I understand it. It's a difficult body of evidence to marshal, but you need to be focused on the issues that this jury is going to need to decide. And that, I think, is really focused on specific intent, which is why I think we all enjoyed the conscious choices and deliberate decisions.
Right, because that speaks specifically to a legal issue. Ken, I want to ask you the shoes. They were making a big deal about how the shoes show premeditation because he allegedly taped them up so that the chemicals could not get to his skin. Is that convincing to you? I
mean, it shows that he was planning for something, and I don't think he was planning to spray their yard with fertilizer.
Yeah. And Brendan, why do you think that they didn't show pictures of the victims? I mean, you have an elderly couple, and the grandmother, she looks like cherubic a little bit, with the cheeks, and then they just look like an innocent couple, and obviously this was so horrific the way that it went down. Why not show them visually if you're showing all these props?
Well, I think also part of the challenge for a prosecutor here is to be focused on the relevant issues, and unfortunately, in a victim case, how the victims looked before a horrific incident like this may not be the most relevant fact as to what occurred on this particular crime spree. So I think remaining focused on the relevant evidence that's going to help prove your point is moving towards relevancy and away from an emotional appeal.
Yeah, but Brendan, that's a very technical approach. We were just talking about all of these different emotional tactics that they used and how effective they were.
Yeah.
I mean, just the mere fact that the prosecutor was showing emotion, was showing facial expressions,
so
was
effective.
Passionate. I mean, Ken, do you disagree with what
so
Brendan's saying?
I do disagree. You know, look, obviously you want to get that relevant evidence in, and you want to tie it all together in your closing argument. But goddamn, you have got to pull at the emotional heartstrings of this jury. And this is a beautiful elderly couple that was gruesomely murdered. I mean, I just want to squeeze their cheeks when I see this picture. And that would have been how I ended the closing argument, showing a picture of them and saying, this couple is dead because of the deliberate decisions and conscious choices of Mr. Eric Campbell.
You've got the accent.
They might get the first-degree conviction on him. I mean, I'm pretty sold.
Mm-hmm. And Brendan, any rebuttal on that? And do you think that if they had shown the pictures, there would have been a valid objection to it?
There would be an objection. Whether it would be valid or not, I think would play out in the appellate courts. Here is the focus for a homicide prosecutor. I remember having homicide cases, where I had a great body of evidence like this. You need to have a long view. It's not just the conviction today, but that conviction must last. This is a capital case. This is a case that's going to go through the appellate courts. It's going to be subject to review. I don't want to create any error if I'm that prosecutor, so I steer clear, or they should, from any issue that could even theoretically raise an issue of appeal.
But then explain that. I mean, why can you show the props, the visual evidence, but you can't show a picture of the victims? Why would that be prejudicial in a sense if you had to argue that side on appeal?
Sure. Well, you're looking for evidence that tells you something towards the elements that must be proven. Elements that must be proven certainly here are wide and sweeping in terms of the intent of the actors, including the father and son, what they did to them. So you can show that evidence. You can show how those injuries were inflicted, what injuries were inflicted. But I don't know what the relevant argument would necessarily be for how these people appeared before this horrific event, other than to appeal to people's emotions. And that's something that I'd steer clear of if I was a prosecutor here.
So then on that point, though, Ken, because this is a good argument here, if he did steer clear of that for that reason, then could you show the pictures of them after?
I agree.
The pictures from the crime scene?
I agree with respect to, you got to get into the relevant evidence when you're presenting your case on trial. But the case has been presented. Showing the victim's picture, it's totally ripe for closing argument. And I don't even think the defense would object to it.
But what's the relevancy if you were to oppose Brendan's argument?
I mean, you could show a before and after.
Mm-hmm. Just to show the extent of the injuries.
Yeah, I think I would have loved to have seen their photo. Look, I don't think the fact that they didn't show the photo of the victims is going to kill their case. I mean, they were very effective.
Is it an appealable issue if they were to show it?
I don't think it's that. I don't think it's so unduly prejudicial that an appellate court would overturn the verdict here.
Now, guys, we had the second prosecutor, the male. He had the blue surgical glove on, and he's literally showing. On just one hand, piece by piece by piece of evidence. Was it necessary to literally show everything that they've already presented at trial, or is it more effective to cherry pick certain pieces? of evidence. Now, Brendan, if you want to hop in there first.
Sure. I mean, I understand you put the evidence in there for a reason. You want to make use of it. There's a theory in a trial of show and tell that you're going to communicate more effectively when you're using props. So I certainly think that that's an effective strategy, whether you're a homicide prosecutor or defense attorney defending someone in these circumstances. I would have liked to see a bit more focus. I think that he could have headlined his sections to steer the jury towards the arguments that he was making and the purpose that he was using those props for. That perhaps would have been a more effective strategy, but I do agree with demonstrating them and showing them to the fact finder here.
Is there a danger of speaking too long? Because if you think about it, a lot of closing arguments do last hours. When is that the most appropriate tactic, and when is it better to sort of cut it off at a more reasonable point? Because I've seen jurors fall asleep at these trials.
Sure. You always have to remember the attention span of your fact finder. You want to make sure you have them engaged, that you're communicating effectively with them. But I think that the jury in a case like this is going to forgive the prosecutors if they go too long or they hover on a point for too long. Because I think they understand that this is a tremendous body of evidence and there's passion here to seek a conviction.
Yeah, I mean, obviously the circumstances of the killings were brutal and vicious. What do you think on that point?
Look, you got to tie it all in. You got to wrap it up in a bow and serve it to him on a silver platter. You got to touch on all the evidence that was introduced, more or less. There might be some minor things that you ignore in your closing argument, but you got to touch on it all. I think the first prosecutor did touch on it all. Mm-hmm. I don't see the need for this guy to get up there. It almost seemed a little bit sexist to me that like the female prosecutor didn't do a good enough job. I don't know. Why did this guy get up there?
The defense had two. And
just because the defense has two doesn't mean we have to have two. And first of all, the defense should have had Southern accents, but that's another point. But look, I think she did great, right? And she had a great closing line, and they should have left it at that. I think that would have been enough. But I don't think he hurt the case.
So was it just this guy's moment in the spotlight and he just milking it? Or
he wanted to have his Michael Jackson moment with one blue latex glove.
What about the fact, Brendan, because we were talking about there's an air of they're disingenuous in a sense. And the reason I think that is because they're making assumptions that are not supported by the facts. And this happens all of the time, where basically you're asking the jury to make logical leaps that fit into your theory of the case, of what happened. Why is that even allowed? And should you be required in closings to stick to the facts and not be able to say that he necessarily did certain things, but watch your language and say, the evidence supports that he may have participated, rather than saying he was there, he committed the killings. I mean, is that prejudicial at all to make those statements that aren't supported by the facts?
Well, certainly if they're not supported by the facts, the answer is yes. But I think what they're talking about here are reasonable inferences. That's the term that's used, that you can draw reasonable inferences from direct and circumstantial evidence. There's a danger there. If you draw a reasonable inference that you believe should be accepted, but there's an equally reasonable inference that is not consistent with guilt, then the jurors may reject that argument. When I'm up there making an argument to a jury, I want them to go along with each and every one of my arguments and not leave it susceptible to attack or to a different interpretation. So I think that they put their necks out a little bit there. And perhaps would have been well guarded to be more reserved in their presentation of what facts could be assumed based on what was proven.
Yeah, so Ken, what's more effective with a jury in your experience? To say that he was there, that he committed the killings, that he assisted, or to say, couch it and be a bit more diplomatic and say the evidence supports it's reasonable that he did this? Would that gain more respect from the jury?
No, there's no place for diplomacy in a closing argument. You are there to
brainwash,
win. You are there to
right?
convince. You are there to persuade this jury to your side. You are there to convince this jury that your side is correct. You have the facts. They are the tools you have at your disposal. And a set of facts can be spun multiple ways. Two people can look at the same set of facts and draw radically different conclusions. And Although I don't know that the defense is going to be getting them to draw any radically different conclusions.
Right, but then really the jury is asked to choose one of two extremes, and there's no middle ground. Do either of you think, and Brendan, you can answer this first, that they will sort of go rogue and find him guilty on the burglary charge, meaning a lesser included charge, and disregard the higher charges that the prosecution is aiming to get convictions on?
I think that here they are in for a penny, they're in for a pound. If they come back with a conviction for burglary in the first degree, I think that it easily flows that he ought to be convicted of felony murder here. I think that the jury will have to completely accept the affirmative defense here that he doesn't have the requisite intent to commit any of these crimes. Because if he does, and I think that there is a significant body of proof here that would support that, I think that he's going to go for first-degree murder.
But under felony murder, do you think that they'll go for first-degree or second-degree murder?
You may see some compromise here, but I don't think that a jury is going to equally be putting their necks out here on this case. There is tremendous proof here of this defendant's involvement in this incident. Really, the only question that I think they must resolve is whether the father's presence in this child's life and the history of abuse was so much and he was so damaged that he couldn't perform or form, rather, the intent to commit these crimes. If he did, he goes for everything, in my view.
You see, I don't think they're going to buy it. They had the brother testify that he could have gone on this twisted family vacation from hell, and he chose not to. He made the deliberate decision, the conscious choice, not to go on this vacation because he saw his father for the threat that he was, and he was frightened by him. I also think, look,
but we know that brothers can have vastly different personalities.
Absolutely, but I don't know that just the fact that this kid is damaged by PTSD or dissociative identity disorder, that they're going to be able to overcome the fact that so many weapons were used here. The extent of the injuries were so vast that it could not have been done by one person or one weapon. And the fact that there were defensive wounds on two people, there had to be another person involved to some extent.
Right. So do you think that that was effective in closing to talk about those different wounds? And do you think that the jury will buy that it had to be two people and not one?
I think they're going to buy it. I think he's going down. I just think the injuries...
There's no DNA. That's a very
big point DNA, here. But DNA is a fickle thing, And first of all, they did say that, like, he had done the things taping the shoes. There's just so much evidence here, without regard to the lack of DNA.
Brendan, you were going to say something.
The lack of DNA is a powerful argument for the defense. It shows perhaps the defendant's lack of engagement with that crime scene in a way that his father was. But I tend to agree with both of you that the evidence here that would tend to show that his engagement is meaningful, it's conscious, it's deliberate, is going to be very difficult for a jury to accept that he was overcome and unable to effectuate conscious choice.
Okay, the prosecution, I would say they took like a lowball shot where they were basically criticizing the psychiatrist for the defense and saying that their psychiatrist had reviewed 2,000 cases, whereas the other one wasn't as qualified, and they even challenged her when she was about to testify. Does that matter, or is the jury's assumption going to be that both psychiatrists are saying what the defense and the prosecution wants them to say to support their case?
Well, I think that you have to have a position that you take because this is a battle of the experts. One expert came in for the defense and said that he was unable to perform this specific intent, and then there was concessions that were gained from the state's own psychologist as well. This is a battle of the experts on this issue of specific intent, so you had to engage and try to take down or discredit the other your opponent's expert witness here.
What do you think,
they have. Look, they're going to be instructed, that jury. They're going to be given the expert witness charge, which basically says, in sum and substance, that they're going to be the arbiters of the quality of that expert testimony. They're going to decide how much weight should be given to each individual expert. And the fact that one expert has reviewed way more cases than the other, that's ripe. in my mind. That's
Does
totally,
it matter how many experts the defense puts on versus the prosecution? Does it have to be equal, or do they all carry the same amount of weight?
No, it's quality over quantity. Sometimes people, they get overwhelmed with the quantity and they mistake the two, but it really should be quality over quantity.
Right. So I think we lost Brendan. Brendan, is that a bathroom break?
Brendan, come back.
Brendan, where'd you go? He's tired of this discussion. So what do you think about the defense doing those? Is Brendan back?
Sorry, excuse me.
Okay. Did you get bored of us? So what did you think, Ken, of the defense doing 2 closings? We already said that the prosecution with the 2 closings, that maybe was a bit of an overkill because we didn't think the second guy was as strong as the first.
Yeah.
How did you compare the second guy from the defense to the first
I thought they were
closing?
both totally lacking in passion. No
Both of
love
them.
for their client.
Double strikeout.
Yeah.
Yeah,
I mean, you want to make your client seem as human as possible, and like, if you, the defense attorney, aren't loving this guy, like you said before, how is the jury going to feel any love for him?
Right, exactly. Brendan, did you catch the defense's closing? What did you? Never even got your take on that. Did you think
yes,
they were
I did.
effective?
I had a slightly different take. I thought that there was components of their closing arguments that were effective. I thought that they were focused on this issue of this overbearing father who had abused this boy and had traumatized him in such a way that, much like any other duress situation, he was a pawn of the father. I found their arguments to be somewhat effective in that regard. I understand certainly what you're saying. I would have loved for them to embrace their client a bit more, because if you are to have a jury accept that he is too a part victim, you're going to have to really believe that yourself.
They were talking a lot about recorded calls from jail. Do the defendants know when they get there that their calls are being recorded? I know it's common sense to a lot of people, but are they told that and therefore they can use it as evidence?
Typically, in every incarceration setting, they are explicitly advised. There's usually writing. They're usually advised by other inmates that every single call that you are making is recorded. And certainly in my time as a homicide prosecutor, we paid careful attention to the communications going in and out of that jail between someone accused of a major homicide like murder and whoever they're speaking to on the outside. So they
then
should
why
have
are they
served
always slipping up and saying silly things that could hurt their case on the phone?
Certainly, that's an argument that he is unwise, but it's a common mistake that's made by many people who are incarcerated.
Look,
Ken,
the
you have an
Campbell
opinion on that?
family is not producing any great minds of the 21st century. I can say, at least in the state of New York, that when someone is in a correctional facility and they make a phone call to anyone except their lawyer, they are told via recording before that phone call commences that they are being recorded,
Right
that they're in a
before.
correctional facility.
Right.
Before. I mean, how brain dead is this kid that he couldn't realize that this phone call was going to be recorded? And in fact, I think they even record attorney phone calls. The only difference is it's not admissible because of attorney-client privilege. And I'll tell you, I've had clients that were incarcerated. I've heard them saying not so nice things about me on those recordings, about my height in particular.
Oh, not your head, because we were powdering your head before.
That's it.
He's done. No, but listen, I have a question about that with his family, okay? Because before you were talking about how his brother basically showed that he had the choice, and he decided not to go with the father, right? So we also heard from his aunt. I mean, to me, both of them seemed very normal. I mean, the aunt was upset that the father had killed ducks for peeing in the pool or the pond or something. She was an animal lover. The brother had a legitimate job. They seemed like empathetic, somewhat normal people. I mean, as much as we can glean from seeing them, their presentation on the stand. So does that hurt, Eric, that they present as normal, nice people, but they're there to defend him? I mean, what they said really reinforced that he had a traumatic childhood and was very much a victim in their perception.
Look, there's no doubt in my mind, this kid is a victim of some horrific abuse. But does that horrific abuse excuse the fact that he took this elderly couple's life in a gruesome fashion?
Yeah.
I don't know. It's
Right.
that's a question the jury's going to have to deliberate on.
Brendan, have you ever faced that predicament where you have people who are there to defend someone in their family, but there's a stark contrast between the way they live their lives and the person that has, like you said, made these choices potentially that landed them in cuffs?
Absolutely. I mean, we all know from human experience that sometimes there's a particular subject of an individual's abuse. Nobody is doubting that Ed Campbell was a vicious, sadistic, sick man who abused basically anybody around him. So I don't think it's a tremendous leap to believe that he would find a central focus in his one son, but not focus as much on others. At the same time, of course, it's a double-edged sword. Their normalcy tends to undermine the picture that's been painted that this was a living hell.
Okay, so thank you guys so much. Brendan, stick with me if you can. And Ken, I just want to thank you so much for being here. We always appreciate your very intelligent and catchy insight.
Thank you, Amy.
Very clever.
Good to see you again.
Thank you. So we're going to toss right now to a clip of the prison psychologist, and then we'll come back and I'll